Namaskar. Namaskar and a very good evening to everyone present here. Today, I, Mansi Chaudhary, take this grand opportunity to moderate today's event. Firstly, I would like to welcome the team of LawInternships. Thank you, ma'am, for joining us. LawInternships is an online law school and recognized startup and recognized by Startup India and Government of India, which shall extensively provide educational services. LawInternships provides opportunities in the field of law to the students pursuing graduate and undergraduate and postgraduate programs, such as internships, certificate courses, training programs, publication services, school kit, and organize events at national level to improve legal skills while being enrolled in a full-time program. The objective is to provide a credible platform for the law students to fulfill educational requirements by imparting practical exposure and relevant skills. In the past 3 years, 2.5 lakh people, including law students, law firms, law universities, have joined us from PAN India through social media handles and services. Thank you for joining us. Now, I would like to welcome our eminent guest speaker, Mr. Mathews, the group head at FOXMANDAL at New Delhi, leads the practice in intellectual property. He completed his master's in LLM intellectual property from Queen Mary University of London in 2011. He is having various publications in his name and got a lot of public speaking opportunities. He is also a member of Bar Association of Maharashtra and Goa. Sir comes with a rich experience of handling varied aspects of intellectual property, including trademarks, copyrights, and designs. His sophisticated legal prowess also supports the clients through the complexities of portfolio management, assignments, and licenses. We are so glad to have you with us, sir. In today's session, we will learn about the trademarks and how to draft a notice of opposition. Before moving further with the session, I would like to brief the instructions to the participants. It is requested to please keep your mic off while the speaker is speaking. If you have any queries, kindly raise your hand or write it down in the chat box at the end of the session. Now, I would take the pleasure to request Sir to enlighten us with his profound knowledge. Over to you, sir.
Thank you, Mansi and Riddhi, for having me over. Good evening to everyone on a Saturday evening. It's good to see a lot of you here. Let's start the topic without wasting too much time. I think Mansi said we'll take the questions at the end. So I think we'll take questions at the end after that. Okay. So I'm going to share my screen right now. And then we're going to start on this interesting topic, you could say, of a notice of opposition. Now, you need to understand why a notice of opposition is of interest to anybody. There are quite a lot of reasons why a person has a problem with or rather would like to oppose another party. And a lot of it stems from the fact that IP is looked at as an asset. So you have to understand that first, intellectual property and more, if you bracket it even more, trademarks is an asset in itself. It's like me owning a car or you owning your mobile phone. You don't want anyone to steal it, right? So very simply put, intellectual property, aka trademarks, in regard to an opposition, is very, very important to any business owner. There have been many instances where people have stolen a trademark and it has resulted in loss to the company at hand. That is something that they don't want to have. And that is one of the major reasons why I think intellectual property and trademarks as a whole is very, very important. Now, oops, okay, sorry. Yeah. Okay, let's start off by understanding the Trademarks Act, because opposition is a statutory provision within the Trademarks Act. We'll talk about that before we go towards an opposition, the process of an opposition, the procedure, and also certain snippets from the online portal as it is today to understand how an opposition is also filed practically. The first thing one needs to look at is basically what a trademark is as a whole. When you wake up in the morning every day, the first thing that one does today is actually look over one's WhatsApp messages or look over a newspaper, which might be that from Times of India, listen to some music, maybe podcast. All of these could be from some brand, some service, some publisher, and each of them is a trademark in itself. I'll give you an example. The Times of India newspaper is a trademark in itself. I listen to maybe the podcast for English Premier League football. That is a trademark in itself. Listen to music, copyrights or IP as a whole, the brand name or the music name could be a trademark. Brush my tooth, use a particular brand of toothpaste to brush my teeth. Again, a trademark. Wear a pair of shirt which is branded. Again, a trademark. So we are constantly surrounded by a world in which trademarks are constantly there. We're interacting with it on a regular day-to-day basis. I would say even on an hourly basis, we're interacting with them. So it's not something which is distant. It is not something which is just in a book. It's very, very real. And as individuals, each of us are interacting with it. And that's as individuals. Now, from a business perspective, because we are interacting with it on a day-to-day basis, this asset is of huge paramount importance to each business owner. If you are a startup and you come up with this wonderful name and you understand the passion from which they speak, the pride with which they speak about that particular business, the particular brand name, it means a lot to them. It's very, very clear and evident. In the start, it might be just passion about that particular name, but there is a story attached to it, obviously, a story many people forget after a while. And it is a story apart from just the asset that one protects today. And that is why many a time they aggressively do not want another person to come into the market. From a commercial angle, obviously, you don't want another party to come into the market because A, it could result in consumer confusion. B, because of consumer confusion, your consumer could go to them and purchase a substandard product, thus affecting your goodwill and reputation. So there are a lot of aspects, and of course, you could lose customers from a monetary standpoint as well, which is not something that business wants to happen. So in a crux, a trademark is very, very important for a brand, for the person who owns it, for numerous reasons. It's an exclusive right, a negative right, a right to prevent others from using it, others from exploiting it. So if I have been given a trademark, it's mine, and I'm going to prevent everyone else from utilizing it. It's a legal protection which is afforded to me. That's understood under the Trademarks Act 1999. Prior to 1999, there was another act, Trademarks Act 1954, which is no longer in existence. It was replaced by the act in 1999 and the rules in 2017. It gives and provides a procedure for registration of a trademark apart from the procedure for combating infringement, combating oppositions, which is a subject matter of today's study. And of course, it has to be distinctive, not descriptive, and it has to not be identical or similar to an earlier trademark. So these are a couple of things which is very, very important to understand, which is there in the Trademarks Act 1999. So once we understand this, we understand why it is important for us to protect it. And that is how we go about protecting it. And that's where within the Act, there's a procedure for an opposition. Before we reach the procedure for an opposition, let's understand the prior stages which are there. So you file a trademark for your client, wonderful. Once the application is filed, it is examined under two sections of law by the Trademarks Registry, namely Section 9 and Section 11. Forget the section numbers, just understand what they are. Section 9 deals with whether the mark is distinctive or descriptive in nature. And Section 11 basically deals with an identical or deceptively similar mark, which may have already been filed for or registered. So you cannot have a mark similar to that. If there is an objection, the Trademark Registry will issue an examination report. Once the examination report reaches you, you will need to file a response to the same. A hearing may or may not be held. It is not mandatory. By and large, we do see that 85% of the time hearings are held. That is at the discretion of the registrar. And once the hearing is wrapped up and orders comes in your favor, the mark will proceed to proceed to publication in the Trademarks Journal. And this is where today's subject matter of study starts from: oppositions. Once the mark is published in the Trademarks Journal, then any third party may file an opposition or initiate an opposition to prevent the registration of that particular trademark. Before 2017, the time period to file an opposition was 3 months, plus you could increase it by 1 month by filing an extension of time. Post 2017, when the new rules came about, it was a clear time period of 4 months from publication in the Trademarks Journal. It's an interesting thing to note that it has to be published in the Trademarks Journal. And it is only after the date of publication, 4 months is calculated from the date of publication. So that's something that you need to keep in mind. The Trademarks Journal comes out every Monday. It comes at around 12 in the afternoon. That's when it's released. Many years ago, let's say 10, 15 years ago, the Trademarks Journal used to be a hard copy, which used to get sent to you. At that time, it never used to come every week. Sometimes it would take 2-3 weeks to reach you. That's how it used to come. But now it's a PDF document, which is there on the website of the Trademarks Registry, which is www.ipindia.nic.in. And you can download it, and all the trademarks which are published in that particular week are mentioned there. Earlier, we used to manually check the Trademarks Journal, but nowadays there are a lot of softwares out there in the market. Most law firms have a software or two which operate to look over the journal and bring out marks which are deceptively similar to yours or your clients. Let's say you come across such a mark, then within the time period of 4 months, you need to initiate an opposition. You don't need to have an application or have filed a register or have a mark registered actually to file an opposition. It's quite okay if you do not have any of these. So there could be a client of yours who may not have filed an application in India, but wishes to oppose a particular trademark because it is similar to them. This is perfectly okay, and you can do this. So therefore, do not be worried if you do not have an application. Do not be worried if you do not have a registration. It's perfectly fine. The Act only says any interested third party may oppose. It does not state that you need to have an application pending or a mark which is registered. An NOP or a notice of opposition is filed in a form known as TMO. This form TMO, the classification of it came about in 2017. Prior to 2017, it was known as a TM5. So there might be many matters, many old matters, where you may come across a form called as TM5. It is nothing but the same TMO which is there currently. It is just a terminology changed in 2017. So just be aware of that. The prescribed fee for filing an opposition or for initiating an opposition is very cheap. It's just 2,700 rupees. If it's filed online, if it is filed in paper physically at the counter in the trademark registry, then it is 3,000 rupees. Most firms now file online. It's just more convenient, more productive, and you also get a rebate because they want you to encourage online filing rather than physical filings. It is also faster because the minute you file it and pay it, the filing receipt is generated on the spot, and the opposition is recorded there against that particular mark. Another important thing what one needs to realize is an opposition is filed per class. Therefore, let's say an application is multi-class in nature. When I say multi-class, it means it covers more than one class. So it's been applied for more than one class. So let's say I was applied for a trademark for class 5, class 25, and class 10. But my problem is basically with class 5. I can oppose just class 5 if required. So I can just file an opposition against class 5. If I wanted to file against all 3 classes, I would have to initiate 3 notices of oppositions against all 3 classes and pay the relevant fee of 2,700 rupees for each class. Please keep this in mind because many a time, a lot of people make a mistake of filing just one opposition and hoping that it's against all three classes. It is not. An opposition only is filed against one particular class. The application as a whole gets blocked. Yes, that does happen. So if I was only to file an opposition against class 5, hypothetically, my entire application gets blocked because it's a multi-class application, which means that I have filed a single application for more than one class. Therefore, if one of the classes is filed, the entire application gets blocked. If you ask what is the solution to overcome that, because well, the other two classes are not blocked, right? The answer is very simple. There is an option for you to file an application of division or a division application. You file that request. Class 5 stays in that particular application number. Class 10 and class 25 move to another application number and moves forward because there's no opposition against them. So this is a solution that you have before you if your client faces a situation where he or she has a multi-class application and only one class is opposed. So this is something that you can keep in mind, because such kind of a solution is what you need to give to your clients sometimes for from a commercial angle action. Now, let's move on to the procedure. The procedure is a little bit more lengthier, though it is not very complicated. Once I file a notice of opposition at the trademark registry, I have a time period. I mean, it's filed within a time period of 4 months, right? So once it's filed within a time period of 4 months, it is served on the applicant. So I file it at the trademark registry, and the applicant is served by the trademarks registry. Once the application is served, rather, once the applicant is served with my opposition, he or she has a time period of 2 months to file a counter statement. Counter statement is nothing but a response to the opposition. Of all the allegations which have been made in the opposition, I will file a counter statement. The important thing to keep in mind in a counter statement is basically this: make sure you counter each and every paragraph of the opposition. Anything that you do not counter, you accept. It's a very simple strategy. And of course, you need to put your grounds as well inbuilt into the counter statement, or your arguments, you can say. Once the counter statement is filed, you have a statutory time period of 2 months to do it. From the date of receipt of the notice of opposition, the counter statement is then served on the opponent or the other side. Once the counter statement is served on the opponent, then the opponent has a time period of 2 months in which to submit his evidence, backing the claims that he's made in his opposition. The evidence here is submitted, a copy is submitted to the trademark office, but it is the other side. The opponent serves it on the applicant. The change here is basically this: the counter statement of the notice of opposition is served by the trademarks registry, whereas when you reach the evidential stage, the evidence is between both parties. So I, as the opponent, will serve my evidence on the applicant and submit a copy to the trademark registry. The trademark registry will not serve the evidence on the other side. So keep this in mind, that you have to send it to the other side with a copy to the trademarks registry. Evidence has to be submitted by way of an affidavit. Therefore, you need the signature of the client or the authorized signatory of the client that you represent. Once the opposition's evidence is submitted, then the applicant has a chance to submit his evidence as well. How we go about it is very simple. We review the evidence which has been submitted to us. And once we have reviewed the evidence, we then go ahead to counter that with our own evidence, which will support our claims made in the counter statement as well. The opponent has one more chance, once this evidence from our side is submitted, to submit any evidence in reply that he or she may want to. If he or she does not want to submit any evidence in response, within 2 months of receipt of the evidence in support of the application, he or she may just write to the trademark registry and to the other side with a copy to the trademark registry, stating that he or she wants to rely on the evidence already submitted. This is a more likely scenario that normally happens unless the matter is such that deserves more evidence to be submitted or countered. Here, the evidence stage comes to an end, and then the matter is scheduled for a hearing. How long does this entire process take? The process, though, which has this couple of boxes on your screen, actually can take up to 2 to 3 years or even more. The even more comes about because of the fact that there's a huge backlog of the registry. We are looking at current oppositions maybe in 2011 or 12, which are being taken. So you're looking at a huge backlog, which is currently pending on the opposition side of things at the trademarks registry. Therefore, if you file an opposition against another party, it is as good as effective as blocking him from getting a registration for the next 6 years, literally, which is not good for business. Imagine if you were on the other side and you receive an opposition and your client does not know whether he or she can use the mark in business for the next 5 to 6 years. It does not help him. He can't hold up business for the next 5 to 6 years. Therefore, it is very, very important that if you face an opposition, see whether it is possible to settle the matter, see what can be done, because you are facing a very, very tough challenge as far as commerce is concerned if a mark is opposed. This is the same reason why, as an attorney, you need to advise your client at the start, before he files his application, to conduct a trademark search. A trademark search effectively helps you and the client to understand whether the trademark is registerable itself in the first place. That search, the advice, is of paramount importance because it helps you from this particular process and procedure of an opposition, which not only eats up your money of the client, but also eats up time to get a mark registered. I mean, there is no 100% guarantee that nobody will oppose you, but at least you may mitigate the risks if there are. Also help the client understand the risks before he or she invests his or her money into filing an application. A trademark is an asset. It has an investment. It can be regarded as an investment by the client, or it can be regarded as an expense. It's completely up to them. We as attorneys always tell them it's an investment, but they sometimes regard it as an expense. Therefore, tell them before you make an investment or take up an expense, at least do your due diligence to understand whether the mark is registerable or not. This is the only thing that as an attorney you can tell your client. He may or may not listen to you, but your job is to advise him in writing, because tomorrow if you're faced with an opposition procedure, you have something to fall back on because you had advised him to conduct a trademark search. Keep this in mind. It's a very, very important step when advising a client for filing a trademark. Okay, now in an opposition, there are always certain sections of law that we fall upon or rely on to base our grounds off. We use section 9, which is the absolute grounds of refusal. Section 11, which says that, your mark is similar to ours. Section 18, which talks about application for registration of a trademark, we will immediately state that the mark is not registerable due to whatever grounds, and that is why we are filing this opposition. Section 21, obviously, is the opposition sections which are there, and we will also likely talk about section 29, which talks about infringement of registered trademarks. By and large, we use these sections extensively when we are filing an opposition and in the notice of opposition at various stages. This is just to give you an understanding where in the opposition you will put these sections in or bring these sections of law in to combat or put forth your arguments is completely dependent on you. Each person, each firm has their own style of filing a notice of opposition. Therefore, you may find varying styles as far as the placement of these sections are concerned. But by and large, these are roughly the sections that one actually looks at when filing an opposition or one relies on when filing an opposition. Forget the section numbers, actually just try to understand what each of them mean, because that's the most important portion that you need to understand when filing an opposition. You will also use these sections in a different manner when conducting a trademark search. You will look at these sections and then see, will I face, or will this entity, okay, I have this search report, I see that this entity is there. Will this entity now oppose me under any of these sections? Am I in danger? Is my client in danger of facing an opposition on the basis of these grounds ever? So you look at it from a reverse scenario when doing a trademark search. Now, the grounds of filing a notice of opposition. Now, there are a couple of grounds that one normally takes. One, and the most simplest one, is it is similar with an identical or earlier trademark of mine for similar goods and services. You have something in clothing, and I have a similar mark in clothing. Goods are similar and identical. The marks are almost same as well. I will not allow it. Why will I not allow it? Well, it kind of, my consumers are going to get confused if there's an identical trademark. And you're talking about the same goods and services, clothing. So, there is no distinction whatsoever which is going to happen. Therefore, I, as a business owner, would not like to have such kind of a person existing in the market to confuse my consumers. It could be a similar or identical trademark, but for a different good or service. So though you may be in the clothing and apparel field, the trademark which is there must be maybe filed for sunglasses, which falls in class 18 or a different class completely. Okay, it's in sunglasses, the goods are completely different. But because sunglasses is an accessory which goes along in my field of work, it is only a natural corollary that tomorrow I may come out with my own brand of sunglasses. Therefore, there is an overlap in the goods. The goods are what we call legally cognate and allied. And therefore, I will not want this particular party to be existent in the market because he cuts out my future scope of development of my business. The mark is devoid of any distinctive character. It's not distinctive at all. It's very descriptive in nature. And by giving you rights or giving that particular person rights over a descriptive term, I too cannot use that descriptive term. Therefore, why do I want him to get monopoly rights over it? So hence, I will file an opposition against him. Again, lack of distinctives, which I've already explained. Likelihood of confusion and deception amongst the public. If there is a mark which creates confusion in the minds of the consumer, especially regarding your product, marketing departments will definitely say, please stop this guy because if his product comes out with this particular trademark, our consumers are going to get confused and they're going to go and pick up his product instead of ours. This may be a substandard product, which may hamper our goodwill and reputation. This may be a product which is not so great. And tomorrow, if the consumers are confused, they would say that it comes from us and not by our product, thus causing harm to our product and our commercial angles as well. So we don't want to have a product with a brand name which is out there, identical to us, and to create confusion. So we will file an opposition. Bad faith. Maybe the other party is trying to pass off as goods as ours. Maybe they're trying to make slight variations in a spelling but phonetically similar marks and trying to pass it and being very smart about it. Their intentions are not good. They just want to ride on the goodwill and reputation that we have as a brand. Therefore, allowing them to exist is a strict no, and we will file an opposition, or it's a ground for filing an opposition. And obviously, contravention of any provisions of the Trademarks Act. Now, this is a provision that is rarely used. We have seen in the past certain marks which have been opposed because they hurt the religious sentiments or something, or just obscene or things like that. It is not something that companies waste a lot of money on, because as far as a client is concerned, as far as a company is concerned, they look at it from the perspective of commerce. They look at the perspective of whether their rights are going to be hampered or not. The provision of law for contravention of any provisions, the Trademarks Act, is there just to allow any interested party to file an opposition if he or she feels hurt in any particular manner regarding any particular thing. This is something that you need to keep in mind, but the main grounds of opposition or filing an opposition for each of you will be the ones that I've prior mentioned. Let's go into the requirements of a notice of opposition. Now, under Rule 43 of 2017, a notice of opposition, when you're drafting it, needs an application number. Which application are you opposing? Where do you get your application number from? From the Trademarks Journal. So the Trademarks Journal will have the application number. It's there, the mark is there, the applicant's name will be there, the goods and services will be there. So these are the main things that you need to inform your client about. These are the things that is there, and these are the things that we will be also mentioning in the notice of opposition when we are drafting it. The name of the opposing party. You are the opponent, you need to mention your name and submit that as well. I mean, you in the sense, your client. The history of your client, because you're the opponent. The first couple of paragraphs in a notice of opposition is all about the history of the opponent, the business, the application. Maybe you file something, maybe you already have a mark registered, what you're using it for, goods and services, etc. Once you provide the history of your client, you will then move on to the grounds of opposition, which we touched upon earlier. The grounds would basically state, these are the grounds on which we wish to oppose you. 9, 11, 17, 18, whatever the sections are. Of course, the opposition has to be signed and duly executed and verified by the opponent as well. So by and large, roughly, these are the basic structures that you need to keep in mind when you're drafting the notice of opposition. A lot of the data you may get from the trademarks journal, especially regarding the other side. When much of the data you may already have, because you may have filed an opposition for this party earlier. So as a good practice, if you already have the history of the client, keep it safely, do not ask them again. Clients are very tricky in nature. They don't want to be disturbed too much. As a lawyer, your job is not to make their job harder, it is to make their job easier. So it's a good practice, keep the history of the client if you've already drafted a notice of opposition before. Maybe the client is a new one and has come to you, but you know that this party has filed an opposition earlier against another mark of a similar nature. Maybe you're able to track that down. The opposition which has been filed earlier is there on record. You can just take the data from there and ask them to verify it by draft. Once you've drafted it, it makes their job much easier. And as an attorney, gives you good brownie points because your client will appreciate the fact that you took the effort to not ask them, but to find it, draft it, and just ask them to verify it. Now, before on your screen, you can see online system. Before the online system, before we have the concepts of digital India and all that, there was a system wherein which you had to go to the trademark registry with a check or a DD in your hand and the notice of opposition all printed out, submit it to the counter, get your filing receipt, and then leave the trademark registry with the filing receipt. They would scan it and upload it. This was the normal process of filing an opposition earlier. Before we even had scanners, it used to be put on a physical file, and then the file would come up with the final hearing with all the papers inside in front of the hearing officer. All the systems have changed over time, and that's a good step in the right direction, I would say. We now have an online filing system wherein which one can 24/7 file any document that one wants to. So today, if I have a notice of opposition and the deadline is tomorrow, I can file it tonight, sitting at my home if required. That's the ease at which we can now do our job as far as intellectual property is concerned. And for those who are maybe under the apprehension that this started during COVID, no, it was there much before that. It was there much before that. Therefore, we should be proud of the fact that India has one of the most, an excellent filing system, an online filing system, which is comparable to many other countries. Does it have its problems? Yes, it does. But doesn't every other system which is out there today? Every other online system, anything which is technical in nature, does has its problems. And they keep working on it to improve it. And that's a good step as well. So the next set of slides that you're going to see on your screen are quite practical oriented. They are screenshots from how the online filing system looks like. So it is much easier to show a person when he's sitting next to you. I've tried to show it as much as possible on the screen, and I'll try to explain it as well. We can take doubts at the end on it as well if you want to. Okay, so this is how your system looks like when you enter into it. On the left-hand side of your screen, you will see TMO. Now, that is the option for filing an opposition. Counter statements are also filed there. So just keep that in mind. So just go under TMO, and this screen will open up. You can see notice of opposition, counter statement, rectification. We're not going there and touching upon all that. These are the various options which are there. As far as today's session is concerned, the first two are of important: notice of opposition and a counter statement. One is where you are initiating an opposition against another party, then you would click on notice of opposition. The second is where it's a counter statement that you're filing. That means someone has opposed your client's trademark and you're filing a counter statement. In that kind of a situation, you would click on the counter statement. And if you click on a counter statement, instead of application number, it asks you for the opposition number. So the opposition number is what we'll need to put in. Right now, it's the notice of opposition has been selected, and that's why you can see application number there. When you move forward, you will see this particular screen, which will come up. If your client has already filed an opposition, you may just search for them and then the details will come up. If they have not, then you will need to add a new opponent by clicking on the tab on the right-hand side of my screen, which says add new, and then you add in the details of the opponent and it gets registered on the system. The rest of the details just pop up automatically the minute you put in your application number. All of the other details pop up, which you can see below you on the screen. You scroll down, you see this box below which says grounds of opposition attached separately, or you can add it in this text box which is here. Nearly all law firms attach it separately. Nobody types it in the text box because the formatting goes haywire. So most of the firms or attorneys draft the opposition separately, convert it into a PDF, and then upload it under the upload option. So you click off grounds of oppositions attached separately, and then you go down and click on upload, which will help you upload all the documents, and then you just submit it. Once you submit it, it goes into the online payment gateway from which you may make the payment. Yeah, so okay, okay, so if you see here, you will see an option for payments. So you have to click on payment, and then you will see your opposition which has been submitted, and then you may proceed to make the payment. Payments can be made by credit cards, debit cards, or online bank transfers as well now. So the three ways that you can make payments of. You can't make payments via Google Pay or any of the UPI apps. That's not possible currently. Credit cards, debit cards, and online bank transfers are currently acceptable across a host of banks. So by and large, this is how one goes about filing an opposition. Like I mentioned, an opposition is very, very important. For me as an attorney, opposition is maybe the only recourse that I have to prevent another party and help my client protect his or her trademarks. Many a time, attorneys file the trademark applications but never enforce it. This is the wrong strategy. You need to enforce your mark. It's as equally important as filing it. You could say that it's two sides of a coin. So one side of the coin has your filing, and the other side of the coin has your enforcement. Under the Trademarks Act, at the Trademarks Registry, to stop someone from obtaining a registration of a mark which might be similar to your client, filing an opposition is important. If you miss filing an opposition, the flip side of it is that that mark will get registered. Now, if that mark gets registered, then you have a problem on your hands, because now you have an identical mark sitting on record. Then you have to go into rectifications, and at the rectification stage, you might be asked why you never opposed him in the first place. It's a lacunae on your part, which will go against you as well. Therefore, be very, very clear about how important this stage is and how effective it is currently. With a backlog, you can use the backlog to your advantage by effectively blocking another person. So there are a couple of firms or couple of companies which will effectively try to block you from getting your mark registered. So understand how these things work and understand how to deviate from it as well. If you are filing an application for your client, to ensure that you don't jump into an opposition, ensure that you do a trademark search. That's the only way you can understand the registrability, chances of registrability, and mitigate the risk of an opposition. Many a time, Indian clients do not hear you out on spending that money for conducting a trademark search, but then that's where, understanding why it is important comes into play, and explaining to them that, listen, if you face an opposition, you're pretty much stuck for 6-7 years. You're pretty much going to spend X amount of money for it. Do you really want to do that? Questions like this needs to be posed to the client as well. Your job is to advise. Their job is to listen and take what you say into consideration, or not take what you say into consideration, but advise them nevertheless. On that note, I'm going to end here. And then I'm going to open the floor to Riddhi and Mansi and the questions that anyone has. And then we take it from there. Yeah. Riddhi, Mansi, over to you.
Thank you so much, sir. We have few questions. So the first question from the participant is, how do you defend trademark in the digital realm, and specifically in context of metaverse?
Sorry, Riddhi, could you just repeat that question again? Just lost
Sure. So the question is, how do you defend trademark in the digital realm? He's asking specifically in context of metaverse.
Interesting question, actually. So, you're not the first person to ask us that question. Now, this is a little bit of a stretch, because right now, nobody today knows, none of the companies today know whether they want to be in the metaverse or not, in the first instance. Currently, what we have is a lot of marketing departments jumping into the fray and saying they are doing it, so let's also do it. And then forcing problems for in-house legal counsels at best. What you need to tell your client first is, do you see yourself in the metaverse in the future? If the answer to that question is no, and it's just a fad, okay, I just want to be there because everyone else is there, then that fad is going to die out in like 2 to 3 months or less than that. If on the other hand, they say, no, we see a future for our marketing, for our business in the metaverse, then you now need to look at how can we protect it. A virtual digital asset can be protected. We can file, or rather you need to check whether your existing portfolio covers this particular area or not. More than likely for marks which are very old in nature, they won't. Therefore, you need to refile those applications or file a new application covering those particular goods and services. And when you do that, then you're fine. The reason why I said ask them whether they see a future is basically because if they don't, then spending money unnecessarily filing it is irrelevant. You may take action on the basis of your current registration also. You may take action or oppose another party on the basis of your current applications as well. Therefore, ask this question, understand what business wants to do, what is the future as far as this particular concept is concerned, before filing new applications covering a particular goods or service, which may or may not be required to be covered at this stage.
Thank you, sir. And the next question is there a possibility to get a registered trademark removed with respect in doing business in India?
Yes. If a mark is registered, you can file a cancellation/rectification action against that particular trademark on the basis that the mark has been wrongly registered or the mark has not been in use for the last 5 years starting from today. Therefore, how do I calculate the second part, the latter part of what I said regarding non-use will come upon basically, I can initiate an action for non-use 5 years after the mark is entered into the register. So only if the mark 5 years have elapsed can I bring the latter part of the section for rectification. The former part regarding that the marks has been wrongly registered, I can bring at any given point of time. However, the onus of proof is very high on the person who files the rectification. He or she has to show quite a lot of things before he or she can get that mark rectified. And once you file your rectification action, the other party will file the response as the evidence stage and will go for hearing as well before it is decided upon. But yes, the minute you file your rectification action, the status of the registration now becomes rectification filed rather than registered. So, when you take out your extract from IP India or the online register from IP India, it shows rectification filed on the top, whereas earlier it would have shown registered, which is a little bit of a headache because when you take that document to anyone, or rather the other side shows a document to people and say, rectification file, they don't even have a registration. That's wrong. They do have a registration which has been questioned actually. But, people can spin it anyway where they want to as far as that status is concerned.
Thank you, sir. The next question is related to a career in IPR. So the candidate is asking that if is IPR a promising field as a career?
Let me see. Oh, there are 53 people on this call currently. I think the answer is pretty evident, right? On a Saturday evening, that too. So yes, it is. When I took up IPR as a field of study, there were 3 people in my batch out of 250 who wanted to do it. Because everybody wanted to do corporate law litigation at that particular point of time. Today, we find in a batch at least 60 to 80 people want to do IP. The number of people who come out of college saying they want to do IP is very large. And the number of seats are also lesser. Slightly skewed because we also see that in this large 60 to 80 number of people, there are maybe 30 or 40 who are very serious, and there are a whole bunch of other people who want to do just about anything. So you will get people who say, okay, I want to do, I like my passion is for corporate law, but I don't mind doing IP tax and everything else also. I think that's pretty wrong because you need to understand where your passion lies, what you want to do before you start doing it. 5 years in college with over 10 to 15 internships, which normally I see on CVs nowadays, you should be able to judge where and what you like in your 5 years. So though it is a very promising field and got a huge scope of growth, You also have to understand that you need to demarcate yourself as a person who has an interest in that particular field when you send your CV to any particular firm. Because the first filtration system is always to look through your CV and see whether the candidate has an interest at all. And how do we gauge that interest? It's not by calling you and asking you, it's by through your CV, through your resume. So though it's a promising field and has a large scope whatsoever, understand that there's also a limited number of seats available for each of the firms as well.
So the next question is related to copyright. The question is, who holds the copyright in AI generated stuffs?
This is an interesting question because we haven't to date actually. I mean, there are a lot of debates happening on this particular question. In India, under the Copyright Act, it's only a legal person who can own a copyright. Therefore, an AI is not considered as a legal person, and therefore an AI cannot hold the copyright. The copyright is normally in the name of the creator. So the author, the author in this particular instance will be the person who created the AI in the first place. So that person can apply for a copyright. If the concept of author includes an artificial being, then yes, then we can look at something as an AI holding a copyright, an AI copyright being issued in the name of an AI. Till that date occurs, we're going to kind of keep the copyright in the name of the person who created the AI. This is currently being debated not only in India, but also outside India in many jurisdictions. There is a whole bunch of things which are happening regarding this. There's a digital act which is coming out very shortly, most probably in June. I think first week of June is going to be issued. That is supposed to have a whole chapter on AI. So we are all waiting to see whether that gives us more clarification. And if that clarification is given, then is the Copyright Act going to be amended if required? So let's wait and see how things play out. But as of today, to date, an AI cannot in India be considered a legal person, therefore copyright cannot vest in them.
So the next question is, can you please elaborate on the division application for multiple class applications? At what stage is it filed? Then is it filed at the time of applying for the mark or when the mark is opposed?
You will never file a division application at the time of filing, or rather after filing your application. Why would you want to do that? If you wanted to file a single class application, you should have in the first instance. You filed a multi-class application because you went with that strategy. So therefore, you can get the multi-class application registered as well. The only time I can file a multi-class application because technically it saves professional fee for the client. So if I was to file 3 single class applications, I'm going to charge the client thrice. But if I was to file 1 multi-class application, professional fee is only going to be once. Official fee is obviously going to be 9,000 into 3 if it's for a company, 4,500 into 3 if it's going to be for a startup, individual, or an MSME. Therefore, if you are forced to file a division application, it has to be either at the examination stage where you feel that objections are raised. There is one class which is problematic, other classes are not problematic. I want the other classes to move forward because I know it can, therefore file a division, keep this to one side and move the ones without problems further. Or if I get opposed in one particular class, I know I'm going to get stuck there for the next 6 years, whereas the other classes I can get my mark registered. So I file a division, keep the problematic one to one side, which is opposed, and move the others forward. So these are the 2 places or 2 reasons why one should actually file a division. You don't just file a division just like that. You'll have to think out your strategy before filing it. It is a way in which you can basically move the classes which are not opposed or not problematic forward.
Okay, sir. Next question is, how does one familiarize with the practical aspect of IPR, like filing opposition? How does one acquire these skills as a student?
Well, you can do this theory and practical. So theory is something that one can possibly learn by reading commentaries, the act, the rules, etc. Practically, you'll have to, if you want to learn it, then you'll have to basically draft it. And for drafting it, that's where your internships come into play. You'll have to basically intern with firms and departments and try to get an exposure to these aspects. So the question obviously is practical in nature. So the answer is also such that you need to intern with firms and request them to let you or show your capability that they will allow you to draft oppositions for them. maybe you will not get to file it because the access to the online filing system is not given to everybody, because I get access because I'm an employee. You will not, because you are an intern. Now we have confidentiality issues, so we will not issue or give our passwords and usernames to anyone. So, but you can always sit with a paralegal and see how it's done. So I guess this is the only two ways that one can actually gain knowledge on this particular aspect, both theoretically and practically.
I think this was the last question. Any participant has any further question? You can either type that out in your chat box, or you can just raise your hand. I feel there are no further questions. Mansi, you can proceed. Thank you.
Sure, ma'am. Thank you, sir, for clearing our doubts. Now, to proceed towards the conclusion of the event, firstly, I would like to thank the team of LawInternships for organizing such knowledgeable webinar. Secondly, I would like to thank Mr. Mathews for making this event a success and enlightening one. Thank you, sir, for sparing your time for this valuable session. Last but not the least, I would like to thank all the participants for joining us and staying with us throughout the session. Thank you, everyone.
Thank you. Thank you, Mansi. Thank you, Riddhi, and thank you all.
Thank you, sir.
If there are
Thank
any
you, sir.
questions, Riddhi, you can just take it from them and just
Sure,
pass it
sir.
to me. I'm happy to answer them for you. Yeah.
All right. Thank you so much, sir. Thank you for your
Most
presence.
welcome. Bye bye. Have a good night.
Thank you.